good afternoon to in-house counsel and in-house legal professionals from all across North America and the world. Welcome to In-House Connect. My name is Shai Mahani. I'm the CEO and co-founder of In-House Connect, and I'm thrilled to have you here with us today. Thank you for spending your breakfast time or your lunchtime with us, and special thanks to our sponsors today, Tangibly and Crown Jewel Insurance, and our fantastic presenters, Chris Buntel and Mary Guzman. They're going to teach us about how an ounce of trade secret protection is worth a pound of litigation, proven methods and missteps to avoid for in-house counsel. This is our 87th webinar of the year, and I'm wondering, are you here for the first time or have you tuned in before? We're thrilled to have with us today for his sixth webinar with us, Chris Buntel, and this will be Mary's first. Chris is an intellectual property attorney with over 20 years of experience. He's co-founder and the CIPO of Tangibly. He is passionate about trade secret management and education, and he has a PhD in chemistry from Stanford and a JD in law from University of Houston. He is joined by Mary Guzman, who is the CEO of Crown Jewel Insurance, a specialty managing general agent providing prime insurance for corporations' crown jewels, which AKA is their ideas and innovations, also known as their trade secrets. With over 30 years of experience in commercial insurance, she is a sought-after coverage consultant. Mary has a comprehensive understanding of the complexities and the nuances inherent in the insurance landscape, driven by her keen insight into policy language and a passion for protecting intellectual property. Mary identified a critical gap in the coverage for the theft of ideas and innovations, an area that is often overlooked in traditional insurance offerings. In response to this pressing need, Mary took a groundbreaking step by crafting the first ever trade secret insurance policy approved by Lloyd's of London. So really cool. We have an awesome panel. I'll turn it over to you. Welcome back for the sixth time to In-House Connect.
Thanks, Shai. It's great to be here. And this is number 6 in Tangibly series, and we have the lucky number 7 coming up mid-November, talking about whistleblowing angles to trade secrets. So that should be really fascinating. And we do have kind of a fun title to today's talk with Mary, but it should be good. So let's dive in and get started. And looking at our agenda, it really is covering trade secrets just to set a level set at the beginning, but then looking at some interesting things that we haven't talked about before, like some SEC regulations, and especially insurance coverage for trade secret, which is a fascinating, fairly recent development in the trade secret world. And then we'll get into some interesting questions, FAQs, and then a couple of case studies at the end. And just to quickly introduce us, like Shai said, I'm co-founder and CIPO of Tangibly, and Mary is the founder and CEO of Crown Jewel Insurance. And we'll have the contact info again at the end of the hour. And in thinking about trade secrets, they're a lot different than the normal government registered types of IP that everyone always thinks about. And both Mary and I love the visual of an iceberg, where the part that you can see, of course, is the small part of the iceberg. And most of the ice is actually hidden underwater. And this metaphor works remarkably well with IP as well. So things like patents, trademarks, and copyrights are the ones that everyone can see. They're very visible, great transparency, but it's actually just the tip of the iceberg. And there's all of this great, super valuable, important stuff hidden underwater. Things like business methods, supplier lists, pricing and margin data, even negative know-how are all incredibly valuable, but totally unprotectable through patents, trademarks, and copyrights. And this is really where trade secrets have become much more important and much more valuable in the last 5 or 10 years, really protecting things that there's no other avenue to protect, but are becoming super important. And like Mary was mentioning just before the call, if you look at the legal definition or the DTSA definition of trade secrets, it is an incredibly broad category. And trade secrets can be on technology, things like manufacturing methods or quality control, but also business related. All of those policies and procedures, and competitive intelligence and pricing models that, again, are totally unpatentable. But there's always this three-part definition that you'll run across. Yeah, the first two are obvious. So the first one is it can't be generally known. Basically, it's a secret. The second one is that it has value due to it being a secret. And you could imagine if something has no value, you probably don't care very much about it. And then the third one is where life gets really interesting or difficult, depending on if you're a glass half full kind of person. But it says that the owner of the trade secret has taken reasonable measures to protect it. And you might think on the next page of the statute, it will say reasonable measures means A, B, C, D. Unfortunately, you'll never find it defined because it's very context dependent. Some trade secrets are incredibly valuable, bet the company valuable. And what's reasonable for that is a lot of protection. You'll put a lot of effort and time and resources into protecting the crown jewels of your company. Other trade secrets might be marginally valuable, or maybe you're a brand new startup and you don't have a lot of resources. So what's reasonable in those situations might be very different than your secret recipe that defines your entire company. And again, you need all three of these to be considered a trade secret. And if you're missing one or two or all three, you no longer qualify for enhanced protection as a trade secret.
Yeah, Chris, I would like to add to that just really quickly that a lot of cases turn on whether or not, of course, you've identified something that gives you a competitive advantage and whether or not you use reasonable measures. But another thing that a lot of people don't really consider is how much time and energy it took you to develop an asset. Generally speaking, trade secret is not the right protection for something where you just had an aha moment or something that is easily reverse engineerable once it's in the public domain, something that you can touch and feel. Those are the things that need to be patented. I think you and I are both on the same page, and we want to make clear we still like patents. We still see reasons for patents. This is not a patent bashing session, but they need to be supplemented and are necessarily complemented by trade secrets. In fact, almost everything in your R&D pipeline is a trade secret until you make a strategic decision to patent it. And so that's something that is really important to recognize.
Yeah, definitely, Mary. And I'm also rocking the latest in Tangibly fashion, got trade secrets on the shirt. But you're right, trade secrets are typically very important, very valuable, difficult for competitors to figure out. If something is easily reverse engineered, it's going to make a very lousy or very weak trade secret. So you have to be wise and thoughtful about how to protect these valuable assets. And we've seen this real trend over the last 5 to 10 years where suddenly there's all this activity, all this interest around trade secrets that wasn't there before. And you might wonder, why is that? What has changed so much? And on the slide, I won't read all of these bullet points, are some of the reasons why. Certainly, there's better protection available for trade secrets than before. And Mary said, we still like patents, but they're maybe less shiny than they used to be. Like patents used to be the solution for everything, and you would just blindly file patents. Unfortunately, that doesn't work so well anymore. A lot of times the patent system is viewed as expensive and inefficient and carries a lot of risk that you might never get a patent, even after disclosing how to use your entire invention, or your patent might become invalidated. There's lots of ways that patents can be attacked these days. The other reality is technology is moving faster and faster all the time. And what we've often found is that by the time you get your patent granted, your technology has advanced so much or so quickly that the patent actually isn't that relevant to your commercial product anymore, because the pace of technology is outracing the pace of the legal system. And then also there's been a lot of shift and a lot of pressure against things like non-compete agreements. the FTC was trying to regulate it, as well as individual states in the US. And a lot of countries around the world are also starting to view non-competes in a negative light that wasn't there before. And then finally, there's a gradual trend of looking at quality instead of quantity in terms of patents. And things that are less attractive for patents make trade secrets more attractive than ever before. We see this trend continuing. Mary and I were at a trade secret dedicated conference about a week or two ago, and that never would have happened 5 or 10 years ago. Like, that's just unheard of. But I actually went to 2 conferences in about a week and a half, purely dedicated to trade secrets. So it's pretty exciting times. And just to scare you or make you aware, trade secret theft, it's a huge problem. They're estimating 1 to 3% of GDP is lost from trade secret theft. If you do the math, that's a staggering amount of money. And the surveys back that up, where between about 1/3 and 1/2 of companies are reporting being a victim of trade secret theft. Personally, I think it's a much higher number. I think some people don't know that they're a victim because they don't even know what their trade secrets are. And then some people probably have been victims and are just too embarrassed to report it in a survey. So my guess is it's somewhere between 50 and 75%. Again, it's a staggering number. And survey respondents are saying about 75% of C-suite level people and board of directors are viewing trade secrets as a really important asset. So again, that sets a great stage for people like myself and for Mary. Also, the amount of money being put at risk in these litigations is becoming quite staggering. It used to be you had to go to patent litigation to get multi-millions of damages. But now trade secrets, it's becoming almost boring to say, oh, there was a $90 million or $100 million. It's become, and Tim Londrigan and I were talking on a podcast about it's actually a good thing that $100 million doesn't get people excited anymore. The high water was still the Appian case, which started off at 2 billion, with a B. That's since been reversed and remanded for a new trial, but it's still shocking or staggering that a jury could come up with that large a damage. And then in July, a $400 million damage was affirmed on appeal. Again, this is awesome that trade secret damages can rival or even exceed a patent kind of damage. So these are
Chris,
great
if I can just add a little,
Go ahead.
add a little color to that. I think part of the reason for that is that juries, although they may not understand the technical nuances of the actual trade secret that's being discussed or trade secrets themselves, they certainly understand David and Goliath or bad guys and good guys. And in trade secret litigation and misappropriation events, there's almost always a bad guy and a good guy. Juries tend to side with the company who created something and had their invention stolen, and they want the other person to pay. And that sort of speaks to why some of these damages claims have been so huge. The other thing that I just wanted to quickly mention that I think was off the radar for a lot of people, there was tons of attention paid to Appian versus Pegasystems. But the minute that claim or the jury award was announced at $2 billion, it became a big problem for the Ds and Os, the directors and officers of that organization, because the stock price of Pegasystems dropped significantly within a period of just a few days. They had a resulting shareholder claim, what we call a follow-on claim, for a securities violation for the failure to either disclose that they had such an issue. They basically did tell their shareholders they were being sued, but they said it was a nothing burger, quote unquote. So you can imagine the surprise when a $2 billion verdict comes down, including a criminal judgment against some senior leadership. Again, as you said, it's been overturned and it's going to be retried. But I think that is a signal of things to come in the D&O space, much like we see in the cyber world. That's my background. I spent 20 plus years doing cyber insurance. I was an early person in that arena. We've seen lots of tag-along claims following privacy breaches. Most of them don't stick because the damages are hard to prove. I think trade secret litigation in the D&O space is a completely different animal because trade secrets, once they're misappropriated, can never be replaced. Never. Their value goes to zero. So if that is the underlying crown jewel asset of the company and it's walked out the door and now all of your competitors have free reign and access to it and they don't have to spend the time, energy, and money creating that asset themselves, they can undercut your price and take a market share and you're done. You're never going to get it back. So I personally think the future of D&O claims around trade secret misappropriation is huge, especially if you're not disclosing what you're doing to protect them, which is, we're coming up on the SEC discussion in a minute.
Yeah, hold that thought. We'll get to it. And you're right. If you read trade secret cases, they tend to be interesting and entertaining because it's a very personal story compared to patent litigation, which tends to be a little bit impersonal with big entities versus other big entities. Trade secrets usually involve one person or a small group of people. And there's always an element of kind of theft or fairness or unfairness to them. So they're a little more interesting to read. And like it says on the slide, you can also have criminal damages. So the longest one that I found in the US was a 14-year criminal sentence for trade secret theft. And to me, again, that's staggering or a really good deterrent. Yeah, I'm willing to do a lot for Tangibly, but I'm not willing to go to prison for 14 years. That's just a little too much to ask. And Shai, we're on to our first poll, which is how important are trade secrets to your business? And we have everything from very important all the way down to we don't have any trade secrets. So it'll be really interesting to see what the trends are.
Looking at the poll, we have a runaway winner, Mary and Chris. You can see the poll, right? Okay.
Yes.
Great. So it looks like a whopping 62% I have selected A, very important, among our greatest assets and are actively managed. All right, followed by 17%. They have some value, but we deal with them mainly once they're stolen. Okay. And then C, we have trade secrets, but they're not very important. And then 9%, we don't have any trade secrets. I bet you do, and you just don't realize it. Over to you, Chris and Mary.
Okay, let's keep moving. And
thank you.
I think you're right on part D. Our position is every company in the world has trade secrets, but a lot of people don't know or don't think about them. So it'll be interesting at the end of the hour to ask yourself this question again and see if it changes. Let me close this window. Okay, Mary, to start off with a really cool topic, this relatively recent SEC rule.
Yeah, if you'll allow me to dive into this for a minute, and even if you are not with a public company, publicly traded company, I think there are some really valuable lessons learned here because I believe with my heart of hearts that investors, private equity and venture capital investors and others are going to be following suit with requirements and questions that they're going to be asking that mirror what the SEC is doing. But most people by now understand that there was a cybersecurity rule, quote unquote, that went into effect December 18th of 2023. What does that have to do with trade secrets? Because trade secrets are intangible assets, mostly stored in some digital form now. If they happen to be the assets that are exfiltrated during security breach, then they certainly fall under the definition of something that needs to be addressed by the cybersecurity rule. So we're going to back up and talk about what it says and how it's relevant for trade secrets. First, it defines a cybersecurity incident, which is unauthorized occurrence on or conducted through a registrant system that jeopardizes confidentiality, integrity, or availability of a registrant's information systems or any information residing thereon. If you've got a breach of confidential information that rises to the level of a trade secret, obviously there's a concern there regarding this rule. The timing of the disclosure is super interesting in that if you determine that there is a material breach, then you have to notify your shareholders and the SEC specifically by filing an 8K, a specific form with the Securities and Exchange Commission within only 4 days of determining that the asset was material. The interesting thing is that the law does not define, or that the rule does not define materiality. And I think they did that on purpose, again, leaving that up to each individual company to determine whether or not something was material. However, The threshold in a lot of cybersecurity sort of mandates and regulations that are out there calls for a really low bar for what meets the level of something that's material, only 0.5% of asset value or 1% of revenue earnings, which is a crazy low threshold. So you think about what's in your R&D pipeline that you've spent $30 million in 4 years developing that's very close to release, and you've made a lot of wrong turns and a lot of iterations making it better and faster and stronger, and a lot of negative know-hows involved in that. That is a crown jewel trade secret. And if it's disclosed, that absolutely will rise to the level of being a material asset. And so I think that's super interesting.
4 days is
One of the
super fast.
Yes, and 4 days is super fast. The good news is they give you 4 days from the time that you determine materiality, as opposed to 4 days from discovery of the incident. There was a lot of confusion around that up front, but they do say that you have to quickly determine whether or not something is material, basically. The other caveat, or the other interesting point about this, is that you're supposed to talk about the nature, scope, and timing of the incident and what is the reasonably likely material impact to the company. Thus far, and we'll talk about this in a little bit, most of the companies who filed 8Ks, and there have been dozens that have already filed 8Ks following the implementation of this rule, the vast majority of them are not addressing the potential material impact and really the scope and nature of the asset that went missing. They're skipping over that on purpose, I would suggest. And we'll talk about the impacts of that and why we think people are doing that. But the rule specifically calls out competitive advantage and things that could damage your reputation as things that they want to know about. And then finally, in addition to having to file a post-disclosure 8K, companies are required now to put in their 10Ks, their annual reports, pulled out and put in front of the normal risk factors section. You're supposed to discuss upfront in the documents what you're doing to identify and mitigate any exposure that could give rise to a material impact or impact to the organization. That means that you're including what consultants you might be using in the process that you've identified to go through that, whether or not you're using third parties to help you with this process, like Tangibly or Crown Jewel or others that are out there trying to help people figure out what their trade secrets are if they don't know. But certainly, this seems to be following some of the patterns that we've seen in the cyber world over the last 2 decades that are now pretty well solidified around having to disclose what you're doing to protect the assets, and then further having to disclose when that one goes missing. I would say we are going to see similar patterns around that. You failed to tell us what the real risk was, you failed to respond properly, you didn't have a proper incident response plan, or you didn't tell us how bad the problem was. Those are the 3 patterns that I think are going to emerge in all of this litigation that's going to come forward as a result of this. And then the real doozy is that, as Chris suggested, a lot of organizations have, maybe intentionally, maybe not, swept misappropriation events historically under the rug because they didn't feel like there was a requirement to disclose. In fact, they pay their law firms a lot of money to try to keep things quiet, because obviously these things could be potentially devastating to your reputation. But now the rule says if you have something that's happened before and you didn't disclose it, you need to disclose it today.
Ready for next slide?
Hey, Mary, somebody's asking, what were the numbers described for materiality?
It's 0.5% of total assets, and I believe it's greater than 1% of earnings or 5% of gross revenue. One of those being after tax and one being before tax. They're very small numbers. And I'm happy to, if anybody wants to email me, I've got details on where I got those numbers as well. So this slide, for those who've never been involved in dealing with a trade secret misappropriation event or trade secret theft event, is really just supposed to give you a thumbnail sketch of how this goes down. Basically, an innovation or process begins with an idea. Somebody says, hey, we're going to create something unique and amazing that's going to give us a competitive advantage. They start to put some oomph behind it. They get some R&D expenses. They spend some money on it. They compile a team, may or may not be within engineering. It could be people over in logistics and supply chain or in your M&A strategy division. Again, trade secrets, unlike patents, a lot of time are born outside of engineering because they can be anything. So they can be anywhere in the company, but you're spending a lot of time and money developing something, and then boom, the asset is stolen. Let's just assume that it's not out in the wild yet. You suspect, based on what you're recognizing from a whole team of engineers that left your company and went to a competitor, you've done some forensics on their machines, and it looks like they were all emailing themselves things at home or downloading things onto thumb drives or whatever the case may be, even though they were supposed to be prohibited from doing that. Now you have to, under the new rule, you have to disclose that issue if you determine that it's material within 4 days. And upon that disclosure, if it's a really significant crown jewel asset, that's when the stock price is going to drop, and then you're going to have a claim. So what you want to be prepared to do is say, potentially we had this theft of material asset that we had identified as a trade secret or a handful of trade secrets that have to do with our designs of our drone technology. I'm making this up. However, we had proper documentation, non-competes, non-disclosure agreements in place. We documented that they were ours and we independently developed them, and that people knew they were not supposed to, leave with this information. And we are going to pursue with our heaviest and boldest, capability to try to get those assets back. That's a much better response than we don't know what to do now. And so that's part of the whole idea behind this. We'll talk about the insurance a little bit more in just a moment, but just directors and officers liability policies only come into play if there is a shareholder suit and they cover essentially the D's and O's for the value of the stock drop. They never cover the value of the trade secrets themselves, nor do crime or cyber policies. And I might have given away the answer to one of our next questions, but essentially the insurance that we developed was to help people pay for those enforcement crisis management expenses, to try to put the genie back in the bottle before it's too late, to preserve the asset as a trade secret by getting an injunction, et cetera, et cetera. And there's really no way to do that if you haven't already identified the assets that are trade secrets, and you can demonstrate with documentation, immutable evidence like what Tangibly creates, that demonstrates that the trade secrets were yours and that you had adequate protection around them.
And we do hope that no one on the call today becomes a victim of trade secret theft. I mean, we hope that if you have good policies, or you train your staff to understand what trade secrets are and how to manage them properly, those should all dramatically reduce your risk of a problem happening. So a lot of what we're talking about in today's webinar is what happens after a bad event happens, but we certainly hope that none of you or very few of you end up in this situation. So moving on to our second poll question, do you believe that trade secret theft is covered by existing insurance policies that you probably already have at work? So this one is going to be very interesting to see how it shakes out.
All right. So do you think that your trade secret theft is well covered? Nope, you're at risk, or I'm not sure if I'm covered or not. And looking at the poll, we have a pretty good number of people answered already. We have 11% of people say, yeah, I'm well covered. It's all good. 25% say, no, my trade secrets are at risk. And then I guess 63%, I'm not sure if I'm covered or not. And frankly, it is really hard to, even when it's like in black and white, it's hard to figure out if you're covered in insurance on anything. Margot says it's so difficult to value trade secrets. Insurance don't like to insure something speculative. Mary, I'm sure you have a lot of thoughts on that. So looking forward to learning more about this subject. All right, we'll close the poll. Back to you, Mary and Chris.
Okay. And I will address that question for sure. So let me just give you some anecdotal feedback here. And obviously, I've not reviewed any of your specific policy wording, people who are listening on this call, and I'm not a coverage attorney. So I just want to put those caveats out there. But I did spend 30 years as an insurance broker running a technology and cyber team for a large broker. And really the whole reason I created my own company is because we beat our heads against the wall for 5 years trying to get the cyber markets at least to pick up the value of trade secrets if they were the assets that were exfiltrated during a breach, and we got nowhere. And I think there was concern about the valuation and how do you adjust a claim, and we've got enough to say grace over with all the ransomware and privacy breaches and everything else. No thanks, was what we heard back from the markets over and over. And it is a really different animal. It's a completely different asset class. It's a very fragile asset that only keeps its protection as long as it's secret, unlike a privacy issue where you can just tell everyone you're sorry and issue a new credit card and move on with your life kind of thing. But cyber policies may cover some of the initial investigation that we talked about, that crisis management piece, if you don't know what types of assets may have been exfiltrated from your system, because cyber policies are always going to have that breach response coverage built in. And until you do a forensic investigation, you may not be sure what has gone missing or not. So there may be some of that crisis management coverage in a cyber policy, but beyond that, there really isn't much. Because even though cyber policies very broadly define what a covered asset is, which includes all manner and size and shape of digital assets, including not only PII and PHI and all kinds of stuff, but also corporate confidential data. Awesome. You read the insuring agreement, and if you close the policy wording, then you are making a big mistake, because when you get to the valuation clause and the exclusion section, you're going to run into problems. One, there's almost always an intellectual property exclusion in a cyber policy, period. And number two, the valuation clause on the first party side of the contract will say that we cover the cost to replace data, period. Not the cost to replace all the time, energy, and money creating the asset that was ultimately stored in digital form. Those are two entirely different things. And so I don't think you're going to find much, if any, coverage on your cyber policy for this. It also does not cover the cost of any kind of outward bound enforcement expense once the investigation is done. They're not going to pay for lawyers to try to go get an injunction and do all of those kinds of things. That's just not what cyber policies are designed to do. D&O, we already talked about. It only triggers if there's already a stock drop, basically, or there's an SEC investigation that triggers then a plaintiff's case. And the SEC investigation itself may trigger the policy. The only thing I would say about that is that there's always a fraud and intentional acts exclusion on any liability policy. Usually there's full severability, meaning that all of the innocent insureds who didn't fraudulently do something are protected until final adjudication around something that it could potentially impute to the entity. The issue is that if the company itself or the board made a conscious decision not to identify and try to get their arms around these assets that were material and therefore weren't able to disclose because they don't know when they went missing or how much they were worth, so they missed sort of the ability to call something material, you may have some issues with the D&O carrier because that was really a business decision not to do something, is my only concern. I'm just throwing that out just as a word of caution. But in any event, D&O policies as liability policies never cover the value of an asset ever, period. They just don't, but they may still protect the board, which is really the point that I wanted to get across here. And then the third policy that could maybe have some coverage you would think might be a crime or fidelity policy, but generally speaking, those only cover the theft of money and securities. If you have, and we can go to the next slide in just a sec, I did not put intellectual property insurance on here for a reason. And that's that most intellectual property policies that are out there are liability policies only. They cover you for allegedly misappropriating or infringing upon someone else's IP, not somebody taking your own. There are a handful of enforcement policies out there that would cover that, some of that initial first part, but as far as we're aware, this is the only policy in the world so far that actually puts a value on the asset and covers that value. How do we do, what is our process to go about this from an underwriting standpoint? Chris said earlier that we were talking a lot about what happens, how the company can react and what you can expect if this bad thing happens to you. But we, in order to get capacity in the market, had to develop a process where we could get the carriers, our backing capacity at Lloyd's, comfortable that we could underwrite this and underwrite it profitably and properly. So if you look at the circle on the left, that if anybody's involved in the ERM, enterprise risk management process inside your own organization or have been historically, that will look very familiar to you, because identify, value, protect, insure, and recover was a slightly different nomenclature depending upon who's explaining it, but that process has been around forever, and it's a baked in process of how you manage a risk, right? Any risk within your organization. For some reason, in the trade secret world, everyone starts at protect. Just throw spaghetti at the wall and hope that what you're doing to protect your other intangible assets is going to work for your trade secrets too. Many companies don't identify, and they certainly don't value those assets. And therefore, as Chris was saying earlier, how can you properly protect the most valuable crown jewels if you don't know what they are, how much they're worth, or who has access to them? Which is why this process exists in the first place. So when we put our insurance together, we started with this fundamental process. And you can read to the right, I'm not going to read everything, but the whole process, the reason we need to identify these assets in the first place for trade secrets is because that misappropriation event on the back end, you're going to be in a world of hurt if you're trying to go to a judge and get any kind of injunctive relief and help yourself in any way, shape, or form if you can't immediately say, this is what our trade secret was, and we can show you it was ours, and we can show you that we limited access to it. And if it gets disclosed, there's going to be irreparable harm, judge, sir or madam, may we please get an injunction. If you can't string that together in today's environment versus 5 years ago, even, it's going to be really difficult for you. The second thing about valuation is once we put a value on an asset, or even if you're just internally valuing using only the R&D expenses that you've used, not the future value of the asset at all, just how much has it cost you to develop something so far? At least then you can rank your assets comparatively to each other and put more time and energy and cordon off and limit access to the ones that are at the top of that list. And that way you can be in compliance with the SEC rule, which says you have to notify when something material goes missing. An added benefit to putting a value on these assets, which a lot of people haven't really thought about, it allows you to monetize assets that otherwise have been sitting there dormant, potentially for years. These are real valuable assets. If it's taken you 10 years to perfect your manufacturing process and the way that your machinery and equipment on the manufacturing floor speaks to each other, the speed, the temperature, which machine's in front of another one, and now you've got less waste, or you're faster than your competition, or whatever it is, that's a trade secret that has a lot of value. Now you can go to investors and lenders and potential buyers in your exit strategy and say, guess what? These assets, which are not currently on your balance sheet, recorded because US accounting laws are way too antiquated for this, but they're valuable. Now you can say we've insured them and we should be able to get a loan against them, or it dramatically increase the value of the company. The rest of them are pretty obvious. Protect, you want to be able to demonstrate that you're showing reasonable measures. We look at not only the technology like we would a cyber related asset, and we're looking strongly at asset control, access control, multi-factor authentication, but also hiring, firing, training, non-competes, and non-disclosures. Those are 5 legal things that are really important in trade secret law. If you don't have a non-disclosure agreement in place, either with your own employees or with customers or third-party vendors or whomever it is that might be co-developing something with you, if there's no NDA, you don't have a trade secret. Almost full stop. And so when people tell you they don't want to sign an NDA and it's a pain in the butt, and do we really have to go back and forth on this? Yes, you do, if you don't have a trade secret. The next thing, of course, is insure for the value of it. Now you can tell your board that you've got your most valuable assets in the entire company insured. They weren't insured yesterday, they're insured now. And obviously it's balance sheet protection, and then enforce and recover. The one thing I'd say there is to stop exercise. Yeah.
Yeah, in some of our earlier recorded webinars, we talked a lot about process and a list of 5 best practices, which we won't go into on this deck today, but it's very consistent with what you're saying. And it all starts with identify. You know, if you don't know what you have, you can't tell when it's been stolen, and you can't tell a good story. And a lot of this around reasonable measures is actually storytelling. You're trying to say that you had great policies, great procedures, great training. You got acknowledgement from people that, yes, this asset is a trade secret. And despite all of those efforts, they stole from you, they stabbed you in the back. And the more compelling your story is, and the more you as a trade secret owner look like the good guy and not the bad guy, the better your chance of success in a litigation or arbitration or whatever dispute resolution venue you find yourself in. It ultimately comes down to how strong and compelling your story is. This is all great stuff. And I created this list of FAQs or kind of questions that I've encountered along the way. And this slide is really meant to be more interactive between Mary and myself. Things like this SEC rule, I often get asked, why is trade secrets not in there? If you do find, nowhere in the rule does it actually mention trade secrets as such. And I was curious, and other people are curious about, does that matter? Does the fact that it never says trade secret make a difference, or is it implied or in there, just not called out specifically?
My opinion is it's implied, certainly, because in the comments to the rule, they specifically said, we want to know about things that are not just direct financial loss, but that could be damaging to your reputation or to your competitive advantage. And at the end of the day, that competitive advantage really is what a trade secret is. I'm not sure why they didn't call out trade secrets. I wanted to scream at the wind when they didn't, because I knew it was going to make my job that much harder. However, I can only guess the reason they didn't is because a lot of people don't know what a trade secret is. So it's easier just to say a material asset that's confidential that was, and dance around the topic. In fact, ourselves at Crown Jewel Insurance, we talked about trade secret insurance for 2.5 years and found that people didn't really understand it until we started calling it crime insurance for innovation and ideas. And then people were like, oh, I get that. But to me, it doesn't make a difference. They definitely are considering trade secrets, especially Crown Jewel trade secrets, to be included in this materiality discussion.
And also, are there any metrics, or do you know roughly how many Form 8Ks are being submitted on this topic? And it's only actually less than a year old now, so it probably hasn't been litigated, but it'll certainly be something with quite a bit of active litigation moving forward.
I don't have a current count, but the last time I looked and did a presentation about this specifically was a couple of months ago, and there were already 35 8Ks that had been filed since the rule went into effect. And what I was talking about earlier, the interesting finding about that to me was that people were very vague about what happened. And I'm sure that was on purpose, right? And you get it. You don't want to put more out there than you need to put out there. It just depends on whether or not the SEC is going to play hardball, or plaintiffs' attorneys recognizing that you that you didn't explain in detail the source and scope of what happened, which is what the rule calls for. I'd be much more worried about plaintiff follow-on than the SEC fines themselves, because they just can't fine you with that significant of a number, really. I think that's where a lot of the big litigation is going to come down. We'll have to watch and see. There were 3 companies at least that admitted that they had emails of senior executives compromised during a breach. That's concerning, right? Senior people in strategy and the C-suite and IT and information security and maybe legal. What was attached, or what was the source of those discussions? Most of the time, they're talking about either vulnerabilities or strategy or M&A or what's their new product rollout or pricing or whatever else it is. There had to be some trade secrets in those emails, and they just chose or didn't know what was attached and therefore didn't say it. The only company that specifically mentioned something about trade secrets, although they didn't call them trade secrets either, was Disney, who said we had future projects, discussions around future projects that were yet to be released, compromised during a breach, which is really
35 is a very small number, and it segues nicely into question number 3 of what happens if the 8K is not filed. I would imagine with all of the publicly traded companies and all of the trade secret issues and hackers and breaches, like it would be much more than 35. So there's probably quite a few that could have been filed, but for whatever reason were not. So that might actually be a much bigger number than 35.
I would suspect that it probably is. Just unfortunately, like in the breach laws that came about, those were really forced on people, hit over the head with PII and PHI, personally identifiable and personal health information around you must disclose and you must notify and you must do all these things. But until those laws were in effect, companies really tried hard not to let people know what had happened. And now what we see looking backwards on a lot of those breaches is that people who didn't notify or didn't disclose properly around those breaches, if they have a second or third breach, or if it comes out 1 or 2 years later that they had an issue and didn't disclose, that's a much bigger problem for them than it would have been had they disclosed in the first place. And again, I think we're going to see a similar pattern. One of the things that's really scary for companies now is that hackers are turning into whistleblowers. There have been at least 2 incidents now where hackers have gotten into a system. The company has not told anyone about the ransomware attack or the information that they were able to obtain during the breach. And so the hackers took it upon themselves to notify the SEC and say, you need to go look into these people because we got their information and they didn't tell anybody. And so it's an ugly world out there in terms of the bad guys. It's depending upon who that's not going to happen more often than not if it's just a couple of former employees. But if it truly is hackers, it may be a different story.
Yeah, it's also a creative, clever way of weaponizing this. Again, it's people who want to do something wrong will always find a way. And it's just, that's a really creative idea I hadn't heard before. On number 4, statistically, the most common occurrence of trade secret theft is a departing employee or a soon to be departing employee, 3 o'clock in the morning, downloads 8,000 files onto their home computer or thumb drive or what have you. Yeah, is that enough of a cyber nexus? The fact that they were logging into a system, downloading thousands of documents, that very common occurrence would qualify as a cybersecurity incident.
Yes.
Any personal thoughts or predictions?
I would say yes, absolutely. And the reason I say that is because the industry has been paying claims for intentional acts of employees downloading private, personally identifiable information for 15 or 20 years now. So certainly that's considered a cyber event under a cyber insurance policy. And I would think as a plaintiff, you'd have a field day making an argument, or as a defendant, you'd have a really hard time making an argument that it was a cyber incident under a cyber insurance policy, but not under this rule, even though it's not defined. And you're right. I think, and that's why when this cybersecurity rule came out and nobody put 2 and 2 together about its impact on trade secrets, it was a light bulb moment for me, because just about everything could be a cyber event anymore, especially if you have a pretty broad bring your own device policy, or your company is using a lot of AI tools. What are you putting in the AI program for the machine learning to work its magic on? And did you disclose a trade secret when you did that? So it's really an interesting question. Chris, you said, is any form of trade secret not a cybersecurity incident? It's hard to come up with one, honestly, except for that I think there are a lot. I did hear one issue. Somebody who's a Department of Justice prosecutor was telling me a real war story about a robotics manufacturing facility where somebody physically broke into the room where the robotics equipment was, broke the arm off of the robot and walked out of the building with the arm. Maybe that wasn't a cybersecurity incident, but it is getting harder and harder to think of something that would not, obviously manufacturing floors and pictures maybe wouldn't qualify, or hard copy drawings of things.
And there was actually a question in the chat. Does an employee's release of trade secret information on Reddit qualify as a cybersecurity event?
That is a good question.
I
would think so. The disclosure on any social media probably triggers us as a cybersecurity event. That's a good question. That's a question for a securities attorney, not me. but I would think it's a disclosure of a trade secret. Whether or not it meets this definition where you have to file an 8K is a different question. But I would certainly ask a securities litigator what they think. I think that it does. It's just my
Yeah, and I
personal
think this
opinion.
SEC rule is going to spawn a lot of very interesting litigations that will gradually resolve these kind of common scenarios.
Yes.
And I know we're running tight on time, so we'll maybe do another slide or two and then leave enough time for interesting questions from the audience. So we have two
Okay.
scenarios, Mary, and just
Yep.
go
So
kind of
I'm just
quickly.
going to quickly run through these. These are meant to just be demonstrative of how the insurance works. We've talked a little bit about that already, that it basically covers all the crisis management stuff. And if we're not successful at getting an injunction and curing the impairment, as we call it, then it actually pays the pre-agreed fair market value of the asset, because it's a property asset that we've scheduled just like you would on a property policy. We pay that value, and then the onus is on us to turn around and subrogate against the bad guy, the villain in this case. And if we are not successful in demonstrating that it was a trade secret or that the client used reasonable measures, that's our problem. So we're giving basically an essential guarantee that something is a trade secret and it's worth at least the value that we've agreed. That's how we created this whole thing. But here's an example of what it looks like today. And we see these cases, Chris, right, all the time, where the client that hasn't identified their assets, they've got an engineering team that walks out the door. They take it, in this case, we're assuming that it's a $20 million asset that goes to a competitor. As it turns out, they didn't document all the negative know-how, and they were not able to get an injunction. And basically, they didn't even have enough data or information for the case to move forward. We're seeing this more and more often where the client can't identify the it or can't demonstrate that they use reasonable measures up front. We call this a lose-lose situation because they lost a bunch of money trying to assert and enforce their rights around the trade secret. On average, to go all the way to trial in trade secret litigation, it costs $4.1 million. So you better feel pretty good that you're going to win. The second is that you've lost the value of your trade secret. And the third is that you have lost the trade secret forever. You can never use it again. So in this case, the client lost about $25.5 million. We assume $4 million in litigation, plus $20 million the value of the asset, just real quickly to show you what that looks like. Fast forward to the next slide, which is where you've bought the insurance. And in order to get the insurance, we looked at your reasonable measures, we looked at the identification of the assets, et cetera, et cetera. Let's just assume that you pay somewhere in the neighborhood of $1 million for premium, which we can work on based on a lot of things, co-insurance, et cetera, deductibles. Crown jewel asset walks out the door. The company quickly engages through us with our legal counsel and forensics team to try to get an injunction and get the asset back. But in this case, again, we're just assuming, despite the proper evidence, we were not able to get that asset, the impairment, cured. So we go ahead and pay the fair market value of the asset, and then we turn around and subrogate. In this case, the client comes out way ahead. And something that I didn't show as an example on these slides is if we are successful in winning in litigation under the Defend Trade Secrets Act, you're eligible potential for multiple damages. And a big chunk of that multiple will go right back to the insured if we're successful during litigation. Just to give an example and get people thinking about how this insurance works, we just included those two slides. And I think that's it for the...
Yeah, I'm going to jump to the closing slide and then leave enough time for questions. I think we'll skip poll 3 just in the light of the time, but we've had a really great conversation. I think insurance and the SEC rule are really interesting aspects of trade secrets that very few people are talking about, but Mary and I hope that this has given you some interesting things to think about. And if you'd like to get more information or continue the conversation about insurance, please contact Mary. And if you'd like to learn more about how to proactively manage your trade secrets to avoid problems like we've been talking about, please let me know either by phone, WhatsApp, or email. We'd love to talk to you. And
So-
time for questions.
All right, thank you, Chris and Mary. There was an interesting discussion in the chat about, I guess, how you evaluate a trade secret. Kathleen and Melissa have been assisting with that. Mary, can you talk about how you would evaluate or appraise a trade secret?
Yes, really, I like to divide things into buckets when I talk about trying to explain something. In trade secret valuation, really the value comes from two component parts for the most part. One is how much time, energy, and money did you spend developing the asset, which includes something we call negative know-how. Negative know-how is what I mentioned earlier, and Chris mentioned it as well, which is all those wrong turns or iterations of tinkering with a product or a formula or a process or whatever until it gets to be, wow, this is really working now, and this is giving us a huge competitive advantage because we've been tweaking it all this time, whatever it is. So if you look just purely at that R&D and the cost to develop something, let's just say that you're at the end of that cycle and we haven't thought about how much money this is going to make you or save you, because it could be just a savings generating asset that's also a very valuable trade secret. Many supply chain and logistics functions are trade secrets and they don't truly generate money. They save money, but they're still trade secrets. The cost to create something and all those wrong turns goes into the development of it. What that translates into, if it gets stolen by a third party, just that piece of it is unjust enrichment. When you seek damages against third party and you're trying to prove unjust enrichment, you only have to show that they improperly took and used an asset where they didn't have to spend the time and energy training people and developing the asset and all of that kind of stuff. So that's why we capture the R&D, because it equates to unjust enrichment, which is a real part of damages in trade secret law. The other half is that nebulous, funky, we don't know really, pie in the sky. What is the future value of the asset? We think this is going to be the greatest thing since sliced bread, and we just solved world hunger. That'd be fantastic if that was true. And we think this is going to be worth $6 trillion, and we spent, $200 million developing it. That's when we need to bring in a third-party valuation expert. Those experts do intellectual property asset valuation for a living every day, either for M&A purposes or for tax purposes. But generally what they're doing today is looking at an entire bucket of intellectual property assets. And instead, we've tasked them specifically, if we bring them 4 crown jewel trade secrets of a company and say, these are worth theoretically somewhere in the neighborhood of $15 million each, but we need you to verify and solidify those numbers for us, then they go through a series of questions. They go interview people. They do a bunch of research themselves on what the competitive landscape looks like. And they'll come back with something that, if it is really far into the future and it's an asset truly that nobody has developed before, then the discount factor they put on that is significantly higher than if it's your 6th or 10th or 12th beverage, and every time you go out with a new beverage you get 11% market share and you don't change the formula for 6 years. You've got a track record and you've done it before, so there would be a much smaller discount factor. But essentially we leave that to the experts. So the more difficult it is to predict something because it's never been done before, which we're seeing in AI all the time, the higher the discount factor is going to be but then the following year, when you re-up or revalue the asset, then you can put more oomph behind it and say, now it's more predictable. We've got revenue from it. We've got 6 clients. We've got 4 in the hole that have already signed a contract. Those are meaningful things, but there are basically 4 different ways to look at the value of any intellectual property asset. But a trade secret, the with and without, the licensing method, it's not called the licensing method, but different ways to look at that future value. But we're really relying on experts to do that.
Yeah, great. Anything to add there, Chris?
Just add that it's quite difficult. Valuing any form of IP is very much an art form and quite challenging. But with trade secrets, it's even harder, especially if it's difficult to attach it to a revenue stream with an NPV or to a cost savings. And Mary said, relying on experts who do this all the time is really critical should you find yourself in litigation or an insurance situation. But it's tough. It's
Definitely.
challenging.
Yeah, okay, let's wrap up here. Mary, I'll throw it to you for closing remarks and then back to Chris, and then we'll wrap up on this rainy New York City Monday.
It's beautiful here. Thank you for that. The only thing I would say is make sure that you follow what I would call a pretty traditional ERM risk management process when you're thinking about trade secrets, and don't start just with throwing things at the wall at the protect stage, because what we're seeing, and we're going, Chris and I, a lot of us now are going to trade secret conferences regularly. We get an opportunity to speak to judges. We're speaking to lawmakers at these conferences who are saying in no uncertain terms, if people are going to bring me a request to do 3 years of backwards discovery to figure out somebody took terabytes of information and there had to be trade secrets in there somewhere, please let us, we're suing for trade secret misappropriation. They will throw that case out faster than your head will spin. It's just not going to pass muster anymore. So you have got to identify these assets. What we hear from clients, we just did a significant survey around in-house IP counsel for Fortune 500 companies about what they're doing on this. And the vast majority of them start with the invention disclosure forms that are in engineering, almost certainly, and look at those first and make a strategic decision about whether to patent or leave something a trade secret. And there's real discussion around that. I would say, though, and Chris and I think both agree, that try to get away from using the term invention disclosure and start talking about innovation disclosure, because again, it could be something completely outside of engineering that's a lot of negative know-how and years of time and effort have gone into developing that truly does give you a competitive advantage. And there are questionnaires and software tools that will help you capture those assets. And you just, in my opinion, you just have to start there.
And Shai, I'll just very quickly add a few comments before we end the session. I still like patents, but I love trade secrets. And I think it's the most dynamic, fastest growing field of IP. And it seems like for every one answer that we get resolved, it creates about 3 or 4 brand new questions that are really interesting and thought-provoking. And I think we're at the right place in dealing with trade secrets. They're super important, super valuable, and we'll together figure out how to protect these assets and maintain their value. So we'll have a long list of future webinars to talk about these things. Thanks a lot.
Shai, if I may, one thing I forgot to mention earlier is that we've done a lot of investigating around when is the last time somebody did a real study on the overall value within the United States of trade secrets, and we can't really find anything beyond 2008. If we extrapolate the numbers at that time that suggested that it was $5 trillion at the moment, that looks like a $35 trillion gap in insurance right now. And so when we go back to that iceberg from the beginning of the discussion, when we talk about this, we talk about the insured assets of most companies are that 10% or 20% of the value of the company that's above the waterline. The rest of those assets, the value of them are uninsured today.
Wow, that's amazing. And we ran poll 3, which is, are you more or less interested in first-party trade secret insurance than you were an hour ago? 60% say yes. Thank you.
Success.
That's right. Be the change you want to see in the world, Mary.
Be the change.
Be the change. All right. We're going to wrap up here. Thank you, Chris and Mary, for an excellent program. Folks, if you enjoyed it, let us know in the chat. Chris, another great webinar. Thanks again. Thank you, Crown Jewel and Tangibly. And thanks everybody for tuning in.